And welcome back. Thanks for tuning into a Morning Live. Now, the New Nation movement, which is a new political party, they are challenging the current Electoral Act with regard to the general elections in South Africa. It's a very interesting case, a case that was heard in the Western Cape High Court yesterday. And the organization is arguing that the current system excludes independent candidates to stand for public office, both in the legislatures as well as parliament. And currently, independent candidates can only contest at local government level, and judgment on the case has been reserved. And we're joined now on the line by Dr. Michael Louis. And Dr. Louis, of course, has been involved in this process for more than 2 years. So he's also going to help us wade through this and understand better what is at stake. And we're hoping to be joined by Neville Felix, and he's a representative of the Khoisan and Associative minority groups who also have an interest in this case. But at the moment, we cross to Cape Town where Dr. Louis is. And Dr. Louis, of course, thanks so much for speaking to us this morning.
Good morning, Shakina.
Now, Dr. Louis, let's start here. If we look at what is being put before the court, the constitutionality of elections since 1999 is dragged into question. But if you could perhaps just, for the benefit of our viewers, just give us a brief background to this case, where it started. You've been involved with it for over 2 years, and where we are right now.
Thank you very much. Well, firstly, I think as an introduction, I'm wanting to say that this is a legal case and not a political case. And 2 years ago, it was brought to my attention that if we're wanting to respect the constitution of our country, that's the roadmap of how we govern our lives, there's a conflict in the Bill of Rights between individuals wanting to stand for public office and the Electoral Act. Now, let me just explain that a little bit. In the Bill of Rights, in the Human Rights section, it says in 1903 that every citizen has the right to stand for public office, and if elected, they should stand. However, in our Electoral Act, it says that you have to be part of a political party, and there's a conflict there. And so this is the main issue that the courts have to now deal with.
Now, if we look at this further, we had Chief Justice Mogoeng also making pronouncement here, ruling that the Constitution does not prohibit independent citizens from contesting national or provincial elections, but that it is the legislation that seems to be lacking here. So please explain to us that, why it exists and why it hasn't been addressed.
Well, the big thing is that that's where the dilemma is, because the Constitutional Court in the My Vote Counts judgment in June last year came out and said that every individual has got the right to stand in public office, not only on local government elections, but also on national and provincial government. The problem is that the Mogoeng went further to say this right is a right that's not prescribed by legislation and needs to be taken up no matter what the logistical constraints are. So the problem are we're sitting 6 weeks before the elections, and the Constitutional Court has made a judgment that he has a human right, and no matter what the logistical constraints are, that right is inhibited and can be taken up.
Now, if we look at the case currently before the High Court, and Judge Siraj Desai talking about some of the language, saying that, you know, it is rather serious, because the applicants who brought this once again before the courts are saying that this could possibly scupper our polls on the 8th of May, because they are willing to follow through and to essentially bring an application to interdict the elections from going ahead.
Well, this is a judicial process, and that's right. This is a right that I think that they must take up. I think it's a right that they deserve. And the unfortunate thing is, Shakina, I'm feeling a little bit sad about this, because we warned the IEC 2 years ago that there's a constitutional dilemma, and that they need to take it up. I started the process 2 years ago, and I actually went to the High Court with an urgent application to mediate with the IEC and say, listen, I'm your arm bearer. He has a constitutional dilemma. Please mediate with us so that we can see how we can rectify it. And unfortunately, that was thrown out of the courts. And now we're sitting at hour number 24 with this constitutional dilemma.
So it's a very interesting point and a dilemma where we find ourselves right now, because if the Cape High Court rules in its favor and declares the Electoral Court unconstitutional, what then, Dr. Louis?
Well, the big thing is that's where the dilemma is, because you actually have, the IEC can only govern the elections by legislation. And that's what happened in December. I approached Honourable Lakota of COPE to start a legislative process in Parliament with a private member's bill, where he gave notice to the public that he wants these independents to stand. The notion was advertised for 30 days. And me and my legal team for the last 2 months have been drafting this bill for independents to stand, and it's currently waiting for certification from the State Department to go to the Speaker. And so if the High Court does rule that this right is a right, we are ready to go to the Speaker, and the President has got the right to call for an urgent sitting of Parliament, then to go and ask this to be legislated. I want to just say the problem is that whatever the High Court says has to be certified by the Constitutional Court, and it means that we need to go to the Constitutional Court with an urgent application, because whatever the High Court in the Western Cape says, it's not really going to have an effect. It has to go to be certified by the Constitutional Court.
But given what the ruling contained last year, as you pointed out earlier, and what Chief Justice Mogoeng had to say, where does that leave us between the two? Because the Chief Justice was clear in his assertion that, of course, it is the legislation that is defective. So what does that mean? How is that likely to play out?
Sorry, Shakini, I didn't really hear that question.
I was saying, given that this case, not in this form, but it has been heard in part by the Constitutional Court. And if we look at what Chief Justice Mogoeng had to say in that ruling, and given where we find ourselves right now in the Cape High Court, the Chief Justice was clear that it was the legislation that needed to catch up with the Constitution. So how is this likely to play out between the two?
Well, the big thing is that, and I didn't hear the question properly, but what I'm going to answer you is to say that we've got a roadmap, we've got a constitution that needs to be honoured. But also South Africa wants to be part of the international stage. And Article 25 of the International Covenant of Political and Civil Rights does clearly state that every citizen has got the right to stand in public office, either directly or by virtue of freely representatives. So if we as South Africa saying we're wanting to be part and recognise on the international stage, this is a human right. This human right has been acknowledged at local level as for independents to stand. For independents not to stand on a national and provincial level is a travesty. Unfortunately, this is a 2-year process that the IEC has been warned. And also, I've warned the IEC in their duties and functions of 51J, they should have advised Parliament a year ago, 2 years ago, that this dilemma is coming. So it's a legal process, and let's see what Judge Desai is going to rule.
All right, we are now joined by Neville Felix, and he's, of course, Khoisan and Associative Minorities Group representative. Thanks for coming through.
Good morning, Sakina, and thank you to the audience.
Let me start here with you, Mr.
Yes.
Felix. Just in terms of the importance of independents being able to contest elections, you've argued, for example, that minority groups such as the Khoisan have been left out of these processes. Why is it important that this particular legislation is passed?
Ma'am, the rule of law, specifically around Section 19(3) and B, it speaks to the fact that everybody in this country has the right to stand for public office. Now, where we find the discourse is the methodology that is utilized in the implementation of that specific process. So you find a situation where you can only register as a political party member, and this then creates a discourse in the whole procedure understood to be democracy, because it creates an impediment for ordinary citizenry to determine who their representative should be in Parliament.
So, in essence, this is about getting individuals who want to contest to stand as president of South Africa or for a provincial position in the legislature to be able to do that without belonging to a political party.
That's correct, ma'am, because the Constitution says we the people. It doesn't say we the political party. And I think the method of which this has created limitations for South Africans to express themselves. We have wonderful people in this country, people with extreme intellectual capability and capacity, but the system marginalizes these people from participating freely and openly in the best interests of all South Africans. And we believe that unless you fix the circumstances that denies us the opportunity as South Africans to push our main players, the best people that we have, forward into the space of representing us, we will not go forward. We would have the dilemma and the discourse that we currently have in the governing systems.
If we could perhaps just take a few steps back, Dr. Louis, how did we end up with this situation to begin with? Why was this left to continue as it is right now?
Sorry, Shakira, I didn't hear the question.
And I do apologize. I think Dr. Louis is just having a slight problem hearing us.
I have got a problem, I'm sorry.
No worries, I'll try again. So, Dr. Louis, I was asking, how did we arrive here and why was this allowed to happen initially, where we actually then went with, as Chief Justice Mogoeng states, a situation that is not prescribed by the Constitution?
So if I hear your question correctly, how did we arrive here? And the problem is that in 1996, when we had our constitution, there was transitional arrangements in Schedule 6 of how we're going to have our political system. And then it was up to us to change it after 1999. And that's why Honorable Buthelezi then already gave mandate to the Van Zyl-Slabbert Commission to come with a new Electoral Act. And the Van Zyl-Slabbert, after a huge amount of effort, came with a recommendation that we need a new electoral system that's accountable. And one of our big problems in this country is that, and most of the residents know it, our politicians are not accountable to the public, and we need to redraft this electoral system. So I blame Parliament, I blame the public officials that for the last 20 years we've known that our electoral system is not right. We as the public, and I've done my application in public interest, 2 years I've started this process to say we need a more accountable electoral system where minorities can speak, individuals can speak. We as the public have ceded our power. We must take back our power so that we can stand and represent who we are and what we represent. And I think this is a Kairos watershed moment. I think we are in a constitutional crisis, but I think the public's not to blame.
And it certainly is a watershed. But Neville Felix, what are some of the impediments facing those individuals and, of course, minority groupings who want to contest elections, for example, this coming election?
Well, the challenge is the system does not actually allow for them to facilitate their ambitions or aspirations to represent the people in their own right. And I think this within itself is an indictment on the definition of what democracy is all about. Democracy shouldn't be having limitations. It should be enabling so that the people's voice could be heard more appropriately and directly at the levels of Parliament. The current situation is, we all know that government has been in a period of transition since 1994. There were certain deadlines that was facilitated, like the gentleman just raised earlier, through Parliament, and the Slabbert-Van Zyl Commission in 2003 presented this to Parliament.
They've been sitting on that report.
Yes. So they've been sitting on the report. So it's not as if this is an unknown factor. The reality is out there that it's in the interest of certain individuals to continue to perpetuate the same situation. And that within itself is a travesty to democracy.
And as it stands right now, of course, Judge Siraj Desai has reserved judgment, Dr. Louis, in this matter. But of course, there seems to be a push by those who brought the application to actually have some decision one way or another before we go to the polls. So in that regard, what do you think is going to happen next?
Sorry, Shakina.
Okay, I'm going to leave Dr. Louis there because our apologies once again. We're struggling with the connection there. But maybe Neville Felix, if you'd like to respond to that as well.
Look, ma'am, the reality of South Africa is that we do have a history. There was no terra nullius when the settlers arrived here. They found people here, and I represent that indigenous Aboriginal First Nation people in South Africa. And I'm so happy that I'm making your acquaintance today because you're part of all of that. We are all an integrated community and a society. But the reality is, unless you resolve your extreme challenges of the past, you cannot move forward. And all of us, in particular as the First Nation, Aboriginal nation, had put our trust into the process leading up from prior to 1910 with the establishment of the governing party. Because we had a situation where Imam Abdul Rahman from 1905 to 1940 represented the aspirations of the marginalized people at the forefront of this process. Ma'am, we've got a history that is a wonderful history, that for the first 150 years since the arrival of Van Riebeeck in 1652, there has been 15 wars of resistance to some of the systems and the dispossession that has happened in this country. And we believe you need to just rectify the process. And we stand for three very clear attributes that we would like Parliament to consider. And the first one is to give recognition that there is such a past. And if that recognition is given, the second best process is to facilitate a codessa of restorative justice. And then from there, we want to talk about the proper processes, recognizing the current realities in South Africa. When we go into repatriation, it can't be a free-for-all and a taking back of everything. We need to find one another as the citizenry of this country, because within our veins lies the solution to the problem of South Africa, because we are hybrids and a mixed race that exists on the southern part of this continent.
Neville Felix and, of course, Dr. Michael Louis, thanks to both of you. As they indicated, this is a watershed. And the New Nation movement, they've said that they will apply for the May 8th elections to be postponed if the Western Cape High Court rules in their favor. And it's going to be a very interesting one to watch, one that argues for the rights of minorities and individuals to contest the presidential and provincial elections. So we'll keep our eyes on this one.